Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-1295 et al. Xcel Energy Services Inc. Petitioner versus Federal Energy Regulatory Commission. Mr. Killian for the petitioner, Mr. Fish for the respondent.
Mr. Killian, good morning.
Yes, good morning, Your Honor, and may it please the court. Under Section 205 of the Federal Power Act, public utilities have to treat all their customers equally. And at this point in the case, I think there's no dispute that under Section 205, the replacement procedures at issue here treat all customers equally. FERC has conceded that the procedures do not discriminate among existing generators already connected to PSCo's grid. Every existing generator is allowed to use the procedures, and PSCo would have no discretion to refuse them that right. The procedures also do not discriminate against new generators who want to connect to the grid. As FERC found in this case, and frankly in every other, the new and existing generators are simply not similarly situated for purposes of interconnection. And when entities are not similarly situated, there can be no discrimination as a matter of law. And so the replacement procedures satisfy Section 205. They're also highly beneficial.
Well, hang on. There's the Federal Power Act prohibits undue preferences, not just discrimination in the pure form that you're talking about it between similarly situated entities, but undue preferences. And the Commission's order here used that phrase, undue preference. And when it talked about discrimination, it said discrimination in favor of PS Colorado's own generators. So it really was using discrimination. There was another form of word for undue preference for PS Colorado's own generators. Now, if that's right, then that's a form of behavior that is in terms prohibited by the Power Act. Is it not?
I don't think so, Your Honor, for a few reasons. FERC has used, in this case and in other cases, the concept of preferential and discriminatory treatment as basically the same thing. Section 205 and 206 of the Federal Power Act are interpreted in pari materia. And whether something is a preference or discrimination or an advantage, in essence, the question is there someone who is being advantaged over someone else similarly situated who is being disadvantaged? And so I think the analysis is essentially the same.
Well, no, but the concept is, I think it may change with the baseline for whom the comparators are. If you're talking, imagine, I know this isn't your case, but imagine you have, a non-independent generator like PS Colorado, and it owns 99% of the existing generation capacity. There's one other non-affiliated generator. Mm-hmm. And it proposes a scheme that says, we're going to make things so much easier for existing generators to hang on to the places that they already have in the interconnected grid. They're going to get to hang on to their connection points by making it super easy for them to modify and update. Now, that clearly, how would that in that 99% or 99 out of 100 generators, to the extent that allowed them to hang on, cement their position for the foreseeable future on that grid, that necessarily shuts out new generation coming in a way that might not happen.
So I think the last
generators had to compete on an even playing field with new generators. Would that be? I'm not even going to use the adjective undue, but would that be a preference? Would that scheme prefer existing generation, 99% of which is owned by the operator?
No, I don't believe so, Your Honor. And the reason I resist the conclusion is that I don't think the last step of the analysis is right, that this even-handed procedure, which would apply even to that one non-affiliated generator the exact same way that it applies to the 99 affiliated generators in your hypothetical, would be a preference unless these new generators were somehow similarly situated. The point of interconnection, as FERC identified in order number 2003, the point of the interconnection queue, I should say, was to provide a neutral and fair way to get new generators onto the grid. As FERC recognized in the Mid-Continent case, what we're dealing with here is essentially an oversight in the pro forma tariff that at the time, no one anticipated, no one was thinking about the fact that you would have replacements one day in the future, replacements that aren't really a modification in the sense that the pro forma tariff uses that concept, and replacements that aren't a new interconnection request either because the entities are already interconnected. And so Section 205, which is the only provision that's really at issue here.
Just to be clear, your view is FERC does not have the power to say that a self-interested operator that wants to set up this sort of rule change, this approach, this analytical change in a way that locks in its own generators at the expense of opportunities even for new generators to connect at all. FERC can do nothing about that.
I want to just push back on that last, that there's no opportunity for new generators to connect. They still have the exact same opportunity that Order 2003 guarantees them.
They don't have the exact same opportunity they would have if those 99 privately owned, operator owned, shall we say, generators had to compete for, as if they were competing for a new connection, had to compete with them for connections.
Well, I think, number one, I don't think there's any evidence in the record that that's actually what's going on here, or even in the case of the 99 in your honor's hypothetical. The interconnection service is just a connection between an existing generator and the grid. If a new generator wants to provide power to the grid, then it just needs to be interconnected. It's not that necessarily that they're going to reuse someone else's interconnection. And if the grid needs more power, the grid will obtain more power. So there's that. Yeah,
but it's easier if you reuse, then it's easier to, you're not going to have to build new structure for the grid. You're not going to have to worry about overload on the grid. So it is different.
It is different. And those benefits inure to ratepayers who don't have to pay for the unnecessary reconnections and building of brand new interconnection facilities in different places on the grid, which is why ratepayers and states are highly supportive of these procedures where they've been adopted throughout the United States. If FERC
said in the 99 case, if FERC said that design, the design of that scheme, design of that proposal, undermines Order 2003's goal of facilitating market entry. And it does so in the hands of the very entities that Order 2003 was most concerned about engaging in self-help, self-preference. And so if they said that in an order, so because it undermines Order 2003's goals in those two respects, we're striking it down. I'm not asking whether that's what they said in this order. I'm just asking in my hypothetical, would that be sufficient?
I think that would put FERC in the position of reaching a result that's inconsistent with the one it reached in the MISO decision and every other one, because the nature of this procedure, whether the operator is affiliated.
I just want to ask whether, let's pretend it's the first decision they make on this subject. They put aside inconsistent with precedent. First time this idea comes up, it's not MISO, but it comes up in my hypothetical company X.
Understand.
Would that be a sufficient basis for rejecting it?
And our first order argument is that would be insufficient because it is still a neutral and even-handed procedure. The point of Section 205 when it was adopted in the 1930s and when it was amended in the 1970s was to regulate integrated utilities and require them to adopt neutral procedures. And the procedure would be facially neutral. There is no opportunity to discriminate in the application of the procedure. And as FERC found in all these other cases, the entities who are claiming to be affected by it, negatively affected by it, are just not similarly situated for purposes of the procedure. And so our first order argument, Judge Millett, is that no, that would be still an impermissible construction of the statute. But a second order argument is that it would put that determination squarely inconsistent with the one in MISO, because by the nature of this generator replacement procedure, yes, it is going to be used by existing generators. That's what it means to, you have to be an existing generator in order to be in a position to replace in the first instance. And so on the MISO grid, which is orders of magnitude larger than PSCo's grid, every existing generator there is going to get the same, advantage, and putting air quotes around that, because that's what it means to be an existing generator. And so FERC,
Mr. Killian,
yes, Judge Walker.
Is part of your argument that your approach would in some way help new generators by clearing out the queue?
Yes, that is part of the argument. FERC found that in the mid-continent.
Can you explain? I don't understand exactly how that would work.
Yeah, so under the current pro forma tariff, because a replacement request is treated like a new interconnection request, new interconnection requests have to go into the queue. And replacement requests have to go into the queue. And it takes a long time to process these requests through the queue. So by removing the generator replacement requests from the queue then becomes focused only on new generators. And so any new generator doesn't have to wait behind a replacement request in order to get through the queue.
So I'm just going to make up numbers, but would it work something like this? Imagine the queue has 3 generators in it. New generator is first, existing is second, and then new generator is third. And each of those takes a year to process. And if you take that second one out of the queue, then the third in the queue, new generator number 2, gets processed after 1 year rather than after 2 years. And I'm following your, okay, I think I'm gonna ask FERC if they think that's factually correct. But thanks for the clarification.
Absolutely. That's our understanding, which is why, this isn't a totally one-sided benefit.
Is that right? What happens to the time? It still takes time to process the existing generators, correct?
The existing, in grids where the replacement procedure is put in place, they're handled like a modification request, which means they're not done through the queue. They're done.
Okay. But the resources are still being expended and diverted to that process. It can't be quite as clean as was suggested. Right?
Well,
you have to spend time doing paperwork and processing and making decisions about it, right?
Yeah, but I think the fundamental importance, Judge Millett, is that in the interconnection queue, you have to study them one at a time, because once then gets connected, the first one is connected to the grid, you have a new grid. And so now you analyze this, whoever's now at the front of the queue, not for what the impact will be on this newly constituted grid. And then that one gets connected to the grid. Whoever's behind it has a brand new grid.
And I thought sometimes they could do them in groups. Is that not right?
I think that may be possible, but my understanding is they are typically seriatim, whereas the modification requests or the replacement request is simply it's a very abbreviated analysis. Are you changing your interconnection? Is the load going to change? And to Judge Walker's question, if you don't satisfy that requirement, if your replacement will in fact have a material impact on the grid, then you got to get back in the queue just like everybody else. So the grid then becomes focused only on generators who are going to have an effect that changes the grid in some way. Simply maintaining the status quo, which is done through modification requests right now, and then would also be done through replacement requests, are handled in this abbreviated fashion.
And if they in the queue as it exists, if what happens is you have someone who's already in the grid and they retire their generator, they just retire it. They're not replacing it or modifying it, they just retire it. And then you take up the person who's next in the line of the queue. Will their process go faster because let's assume that they're not going to generate more power onto the grid than the retired one did? Would that not facilitate their process?
I would say it's possible, but it's not guaranteed, because each of the interconnections is geographically based as well. And so if a generator connected in, the northwest corner retires, and the next one in the queue wants to be in the southeast corner of the grid, there may be no, benefit, if you want to call it, no way to abbreviate the analysis. The place on the grid where the new load is introduced is not the most important part, but a very important part of the analysis. Which is another reason why these replacement requests, aren't necessarily going to, benefit any new generators. But I guess I just want to emphasize this point. I've run over my time, and but before I sit down, I'd like to emphasize this point. I think FERC's construction of Section 205 here, which essentially says that our affiliates' participation in a neutral and generally applicable benefit that renders the procedures unlawful, that turns Section 205 on its head. FERC is saying that this is discriminatory or preferential because everyone could take advantage of it. And that is absurd. We don't have to discriminate against our affiliates. We don't have to carve our affiliates out of neutral procedures in order to satisfy a non-discrimination duty. And that is essentially what FERC has held here and what FERC advances in the court now, that the only way for us to not discriminate is to discriminate. And that's illogical. It's the essential reasoning beneath the order here, and which is why this is the only order where FERC has rejected one of these procedures. For that reason,
it's also the only application that involves administration by a non-independent, self-interested.
we were the first, not the only. The Dominion.
Well, Dominion has an independent entity doing its administration. Is there another one that has, it's like you, it's not independent, and it doesn't have an independent entity doing the administration that they have granted?
Not that I'm aware of, Judge Millett. No.
So you're different. You're not similarly situated to the others.
I strongly resist that conclusion, Your Honor, because the difference between being affiliated and unaffiliated doesn't affect whether or not the practice is discriminatory. If the practice is neutral on one of the largest grids in the United States, the fact that we are affiliated with 60% of the existing generators does not turn it into a discriminatory practice on our small grid in Colorado. And so because it doesn't violate the statute, and because the procedure generates the exact same very large systemic benefits on PSCo's grid that it generates on MISO's grid, FERC cannot conclude that this is somehow not consistent with or superior to the pro forma tariff. The conclusion below, for that reason, is arbitrary, capricious, and contrary to law.
Okay, we'll give you a couple minutes in reply. Mr. Fish.
Thank you.
Good morning, Your Honors, and may it please the court, Jared Fish for the commission. Mr. Killian just said that everyone can take advantage of their streamlined review policy. The only way he can say that is if he restricts the universe we're considering to existing generation and forgets about PS Colorado's policy's effect on new generation. That rests on an erroneous premise that this entire case turns on. And that erroneous premise is that new resources seeking to interconnect to PS Colorado's grid are not similarly situated to existing resources that seek to replace their generating facilities.
Mr. Fish, can you pick up where Mr. Killian left off with regard to the independent entity that's overseeing that could be ordered to oversee the replacement of existing generation? It's just unclear to me how that helps new generators at all, because in Dominion, the independent entity is there, I suppose, to make sure that Dominion doesn't discriminate between its own existing generators and other companies' existing generators. But that independent entity isn't involved at all, as I understand it, in the process for new generators. And in this case, your concern was that the discrimination would happen against new generators. So how would an independent entity help that at all?
Your Honor, this case is the only one on review, so I can't really speak to what the commission did in a later order in Dominion.
We could just make it let's just make it a hypothetical.
The commission could find that if you have an independent entity administering a streamlined interconnection review process, then it could weed out discrimination in the facilitation of that process. But we rested this.
But the independent entity that is overseeing the process for existing generators would do nothing to protect new generators, correct?
That may be correct, Your Honor, but we did not rest this decision on that principle.
I thought this decision rested on your concern that there would be discrimination against new generators.
Exactly. That is correct, Your Honor.
And the independent entity does nothing to prevent discrimination against new generators, correct?
I believe that's probably true. I'm not going to prejudice any challenge to the Dominion order, which came after this case. But the court, even in the Altamont decision that PS Colorado cites, does not stand for the proposition that this court will reach out beyond the record here to another case, a subsequent case, where we departed from our policy and the decision on review to undermine an otherwise lawful decision on review. And this decision is lawful because we reasonably construed our order 2003, which says that for a non-independent system operator to depart from the default interconnection review process, it has to show that its proposal does as good as or better than the default in not favoring its own generation. And
let me, Mr. Fish, share an analogy that's been on my mind. It is admittedly a very imprecise analogy, so I say it with some caution, but I'm trying to think in my head to something to compare this to. So the concern here is that, as you said a moment ago, that the entity that Xcel may discriminate against new generators in an unfair way. So imagine that there's a principle of law, a Supreme Court precedent that says, in the context of jury selection, old jurors and young jurors are not similarly situated. It's fine to strike old jurors because they're old. It's fine to strike new jurors because they're young jurors because they're young. I'm not saying that this would be a good precedent at all, but I'm just saying, go with me here. Imagine that that's the precedent. The precedent is young jurors, old jurors, not similarly situated. And now there's a Batson challenge because an African-American juror is struck. The prosecution says, well, we struck that juror because of the juror's age. And the defendant comes back and says, well, that's pretext. I can find another juror, a different race, who is exactly the same, who you didn't strike. And the only difference is, other than their race, their age. Now, in that situation, it seems like the district judge would have to say, you're not comparing two similarly situated jurors who are different only because of their race. You're comparing jurors who are not similarly situated. One's old, one's young, one's old. Now, tell me why that analogy is not like this case.
It's not like this case, Your Honor, because so there you're talking about under one scenario, whether two distinct sets of entities, persons, are similarly situated or not. Here, where the commission found that new and existing resources are not similarly situated was in a totally different context. It was in a different case, considering a different set of issues, where you had an independent system operator, Mid-Continent. And there, at paragraph 63 of the Mid-Continent order, we said, in this circumstance, new and existing resources are not similarly situated. Why? Because the issue there was whether, for practical purposes, it made sense to streamline the interconnection reviews for existing generation. And we said, yes, it does. In that way, new and existing are different because existing resources already went through the interconnection review process once before. But here the issue is different. Here the issue is whether PS Colorado's proposal favors its own generation, of which it owns 60% on its grid under Order 2003.
I understand how there are some factual differences here. Tell me how you can still win if I come to the conclusion that the MISO case establishes a principle that new generators and existing generators are not similarly situated. I know you don't think it stands for that principle as broadly as I just stated it, and you might persuade me of that through your briefs and through what you say there, but assume, just for the sake of this question, that MISO stands for the principle that existing generators and new generators are not similarly situated. Is there still a way you can win this case?
Absolutely, Your Honor, because here, PS Colorado, as a non-independent system operator, is not similarly situated to MISO or Mid-Continent, which is an independent system operator. And that makes all the difference because Order 2003 is all about not allowing transmission providers to benefit their own generation. Well, that immediately distinguishes PS Colorado from Mid-Continent because Mid-Continent owns no generation. So there is no specter of Mid-Continent favoring its own resources, whereas here there is. And because and by the way, it's petitioner's burden under this court's precedent and transmission access policy study group, it's petitioner's burden to show that there is no reason for the difference in treatment. I just gave one that goes to the core of Order 2003. And so once we accept that PS Colorado as a non-independent system operator is not similarly situated to Mid-Continent, which is an independent system operator, then under this court's Baltimore gas precedent, we don't need to explain a different outcome. And so the Mid-Continent case drops out of the equation. And the only question is whether, in this case, we reasonably interpreted our own Order 2003, which says that a deviation from the default procedure must do as good as or better than the default in not allowing a transmission provider to favor its
And
own.
from whose perspective? And this is not a hostile question. I'm just trying to figure out how the standard works. When you say consistent with or superior to the default procedures, superior to the default procedures from the perspective of who?
The commission in implementing the goals of Order 2003. And that is, as Judge Millett was stating, that was to ensure that there is an open marketplace, a competitive marketplace, where new resources are on the same playing field as existing, or new resources are in the same playing field as a transmission provider's own resources. And by the way, what PS Colorado is arguing here is pretty radical. There is no other case where the commission has said that we find undue discrimination where a transmission provider favors its own resources over independent resources, except where you're only doing so over new resources. You're not discriminating against existing, but it's fine to discriminate in favor of your resources over new resources. We've never said that. And this is a principle of undue discrimination that goes back to at least 1996 with Order 888, where we did there for transmission access what we're doing here for interconnection access. And so it's PS Colorado's formulation that is pretty radical. And just to go back, Judge Walker, I know you're not, just going back to my argument that new and existing are not similarly situated for this purpose, I know of no case, and PS Colorado has cited none, that says just because two sets of entities are not similarly situated for one purpose means that they're not similarly situated for all purposes. And, here we're talking about a different issue. And if they're correct, then
what is the different issue? Can you just finish that thought? Spin it out for me?
Sure. The issue in Mid-Continent was whether it made practical sense to allow existing generators to go through a streamlined interconnection review process. And we said yes, for all the reasons PS Colorado states, because there are efficiency benefits to that.
And here, how are they similar? How are new and existing generators similarly situated in this situation in a way that they were dissimilarly situated in MISO?
They are similarly situated here because for purposes of effectuating Order 2003's goal of not allowing transmission providers to favor their own generation resources, it doesn't matter whether we're talking about favoring their own existing generation resources over third-party owned existing generation resources, or favoring their resources over new third-party owned generation resources. Order 2003 makes no such distinction between existing and new. It's just concerned with preferential treatment of one's own generation resources. I have a quick hypothetical if the court will indulge me. I see I'm over my time, but
Go ahead.
Okay. Thank you, Your Honors. Say a city passes an ordinance that says all motor vehicles should be tested for emissions of carbon dioxide on an annual basis. And the city says, okay, well, we find that electric vehicles and gas-powered vehicles are not similarly situated to effectuate that goal because electric-powered vehicles have no emissions. So we're not going to require electric-powered vehicles to go through annual testing. Later, the city passes another ordinance that says all motor vehicles should have their tire treads tested on an annual basis. We're concerned that smooth tires cause more accidents and cause more injuries. In that circumstance, the electric car manufacturer cannot swoop in and say, wait, you can't apply your tire tread rule to us because you've already said in the emissions context that we are not similarly situated to gas-powered vehicles. Whether two entities are similarly situated or not depends on the goal and the issue that we're focusing on. The issue here, a preferential treatment by a transmission provider, simply did not exist in the Mid-Continent case because Mid-Continent owns no resources on its grid, nor could it. It's an independent entity, and it would.
I guess I'm sorry, because I know you're going to say the jury can't consider it, but in this case, in a subsequent order, you approve of PS Colorado did because they have an independent entity, I think just policing, as Judge Walker was asking, how this process is administered as between existing resources, the same thing you did in Dominion. And so what I'm trying to square, and I mean, if you want to repeat and just say you can't even think about that, go ahead, but I hope you'll have a better answer than that. And that is, how did that fix this? I understand the problem you're telling me about here, but I don't understand how PS Colorado having an independent entity fix that problem. Can you help me understand that? Just
I understand. There is a bit of daylight. So, as PS Colorado itself argues, in our initial order, we said there may be opportunities for discrimination. There could be opportunities for discrimination. And reasonably, that concern applies in two ways. It applies as concerns existing generation vis-a-vis new generation, and it could also adhere in a concern over implementation of an otherwise facially neutral policy that applies only to existing generation. So to the extent that we were at all concerned about that other issue here, then the independent administrator in Dominion and the subsequent PS Colorado case, would resolve that. But
Can you point to anything in the orders here that says that was one of the two? That was a dual concern case. You were concerned about discrimination in the administration of this program as between existing generators. Is there anything in either the order or the rehearing order here that talks about that?
Not beyond the what I think would be a reasonable inference from paragraphs 35 and 36 of our initial order. But I think the stronger and the dispositive argument is this court in Altamont, in Brooklyn Union, in Baltimore Gas makes very clear that this court does not undermine or does not render unlawful an otherwise lawful order on review just because an agency swerves away in a subsequent order. The only question here is whether we complied with our precedent, and that requires first finding that we are similarly situated to the entities in our prior precedent. I just explained why we're not similarly situated to Mid-Continent. And if there is no unreasoned departure from similarly situated entities in our past precedent, then the only question is whether we acted lawfully in interpreting the governing law, which is Order 2003 here. And like I said, Order 2003.
Well, if just procedurally, if PS Colorado goes, okay, now here we are in November 2021, and the wheels are coming off because FERC let us do it with this independent entity, which isn't addressing at all the problem in either order. And they let Dominion do it with an independent entity, which again is not addressing this problem of undue preference vis-a-vis new generation. How could PS Colorado come to FERC and say, you got to admit now that your concern was not undue preference vis-a-vis new generation? And since that's not, we shouldn't even have to have the independent entity because you didn't remotely for a second suggest that you were worried about discrimination between the 60-40 existing generation. How would they do that?
I'm not sure they could do that, Your Honor. I mean, one way might be to challenge the Dominion or its own subsequent PS Colorado order and say this is unlawful because in the orders on review here, FERC, you didn't say that you need an independent administrator to remedy any perceived undue discrimination, and so the subsequent PS Colorado order is unlawful. It's an unlawful departure from precedent.
Right. So the only way they can get us to look at this problem, at least as they perceive it, that has now been exposed, and at least one commissioner agreed, is to seek review of the order directing independent entity.
I think that's right.
They still have time to do that?
I don't believe they do. I'm trying to remember exactly when. But let's see. That order was issued back in May, so I don't believe they do. But they the writing was certainly on the wall. If they wanted to say that order is an unreasoned departure from prior precedent, and certainly they would be similarly situated to themselves in the orders on review here, then, then there's at least a basis for saying, okay, FERC, you committed an unreasoned departure from prior precedent. But I know of no case, and this court's case law goes sharply the other way, that says a court will reach out to a subsequent decision to render an otherwise lawful order unlawful. So, I think it's an important procedural distinction. But, I would just close by saying their premise that new and existing resources are not similarly situated for all purposes, regardless of the context, just because at paragraph 63 of the mid-continent order, we said, in this circumstance, new and existing are not similarly situated, it is simply erroneous on the law and would undercut our ability to exercise our wide discretion in combating undue discrimination. Thank you, Your Honors.
All right, Mr. Killian, why don't you take 2 minutes?
Thank you. It's not just the MISO order where FERC identified that new and existing are not similarly situated. In paragraph 13 of the rehearing order in our case, FERC reiterated that same finding. FERC has never abandoned the finding that new and existing generation are not similarly situated, not before our case, not in our case, and not after our case, because it's an undeniable truth. The MISO decision—
But then it does go on in that exact same order to say, look, rather, the problem here is
our participation in the neutral provision. Yeah.
Rather, the commission sought to ensure that PSCO, as the entity proposing reforms that stands to disproportionately benefit replacement of its own generation, is not afforded, where I began all this, undue preference over developers or owners of third-party generation. So it was drawing the very distinction that Mr. Fish has referenced. Right. As for these purposes, sir, you're maybe similarly situated, not similarly situated in one sense, but to the extent we have this concern, it continues, or it exists. It is not affected by that.
In our response, Judge Millett, is that is not an appropriate concern in this context. When there is an even-handed procedure, it is not unlawful because it's even-handed.
Okay. So this case boils down to that legal question, whether it's legitimate under the Federal Power Act for them to have that concern about undue preference of their own existing versus new. That's really all that's at issue.
That is the first order issue. Yes, that is somehow violates the act in order by our compliance with the act and treating everybody equally. We treat everyone the same, including ourselves, and therefore we violate the act. That we challenge that logic as arbitrary and capricious.
Mr. Killian, can you respond to Mr. Fish? Do you agree with Mr. Fish that we can't look at the orders that occurred after this order? We just have to
no, we disagree. We do disagree with that.
What's your authority for disagreeing? Because he does have some solid precedents on his side there.
Sure. And the cases he cites are cases where an entity who lost in its case points to subsequent cases, usually years after the fact, and say, hey, agency, you affirmatively changed your policy. Apply that retroactively to me. But in our situation, the order, number one, came out a few weeks afterwards. The Dominion order was a few weeks afterwards. And in that Dominion order, there are several paragraphs where FERC is purporting to talk about our order. FERC completely recharacterizes the PSCO decision in paragraph 26 of the Dominion order and says, actually, this was all just about discrimination against other existing generators. And as Judge Millett noted, and as then Chairman Danley noted in his concurrence, that doesn't appear on the face of our orders at all. A concern about PSCO somehow applying these procedures in a way that discriminates in favor of its affiliates and against unaffiliated existing generators was a concocted rationale. And so we point to the Dominion order to Judge Walker to show that the FERC here is just bouncing around. Every time they get pushed on this, they come up with a brand new argument. And in this court, we think they're advocating a new argument as well, that the mere participation in a neutral benefit somehow renders it discriminatory or unduly preferential. The essential logic—
Why wasn't your avenue at that point— I understand your argument. Why wasn't your avenue then to seek review through the order approving your plan with the addition of an independent entity and go, look, we're getting hit from every direction. We don't know what's going on.
I have to say, Judge Millett, I've never seen someone who petitioned for something and obtained exactly what they petitioned for, then file a petition for review in this court and saying I shouldn't have asked for what I got for.
I know, but you're a good lawyer. You would explain why you're actually still injured.
I would do my best in that situation, Judge Millett, but I do think that it would present some serious questions that you're seeking on a petition for review, something that you did not ask the agency for in the first instance. We asked for it. We did it in this proceeding, and we were rejected in this
Could you have not, did you file another, application to have it approved with the independent entity?
We did. That
And
was the
so
one.
could
that
you
was
have not
petitioned.
then, at that application stage, said two things? One, we think you should go back and reconsider your initial decision in light of what you just did in Dominion Power. Because these are not making sense to us. Or two, if you can make it make sense, then approve it with the independent entity. You could have done a two-track approach in that application that would have allowed you to bring the Dominion story into the record and into the analysis before FERC.
I'm not sure, Judge Millett, that we could have done something like that. So given that we're in this case right here, where we did raise exactly these arguments, I mean, I do think we're not saying that FERC consciously changed policy in the Dominion case and that conscious policy change should be applied retroactively to our benefit. What we're saying is that FERC has treated us differently. The APA principle of treating like cases alike does not require the court to turn a blind eye to the agency immediately switching its rationale in a few weeks afterwards and purporting to give an explanation for our decision that doesn't even withstand the actual assertions in our own decision. If I can conclude, Your Honors, Order 2003 is not anti-integrated utilities, and neither are Section 205 and 206. The solution that all the statute and the Order 2003 proposed for integrated utilities was to require equal treatment. That is exactly what PSCO has proposed in this situation, and FERC's conclusion that our compliance with the statute somehow violates the statute is arbitrary, capricious, and contrary to law.
All right. Thank you, counsel. Madam Clerk, would you call the next case?
Case number 21-7003, Process and Industrial Developments Limited versus Federal Republic of Nigeria and Ministry of Petroleum Resources of the Federal Republic of Nigeria, appellants. Mr. Major for the appellants, Mr. Clason for the appellate.
Mr. Major, good morning.
Good morning, Your Honors. Chris Major for the appellants. May it please the court. Nigeria did not impliedly waive its sovereign immunity under the Foreign Sovereign Immunities Act by signing the New York Convention and then subsequently agreeing to arbitrate against PNID in England under Nigerian procedural and substantive law. As this court has held in case after case, the implied waiver exception under the FISA must be narrowly construed. Finding implied waiver requires unmistakable evidence that the sovereign intended to waive immunity under the acts that are alleged to be the implied waiver. Earlier this year, this court in the Ivanenko case noted that there's only been 3 circumstances in which this court has found implied waiver of sovereign immunity. Number 1 is executing a contract containing a U.S. choice of law provision. Number 2 is filing a responsive pleading in a U.S. court without asserting the sovereign immunity defense. And number 3 is agreeing to submit a dispute to arbitration in the United States. In all 3 of those circumstances, there's either contact with the United States or submission to U.S. law. Critically, none of those circumstances apply in this case. The gas supply and processing agreement at issue in the arbitration was for a project in Nigeria. The agreement was governed and construed in accordance with Nigerian substantive law. The parties agreed to arbitration under the Nigerian Arbitration and Conciliation Act, and the venue of the arbitration was London, England. There was nothing mentioned in the agreement about the U.S. and certainly nothing about sovereign immunity.
Well, the convention and the legislation enacting into positive law into the United States Code here talk about the power of courts to order arbitration, to enforce the agreement to arbitrate, not just the awards here, but up front. for order arbitration. How could they do that if the parties were not waiving their sovereign immunity to be subject to such order and authority?
Yes, Your Honor. And the pre-FISA cases that dealt with the with implied waiver and arbitration all dealt with the circumstance of arbitrations taking place in the United States. And the logic was, how can you have arbitration in the United States as the sovereign had agreed if you can't go to US court and enforce the arbitration agreement and require the sovereign to actually fulfill its specifically agreed obligation to arbitrate in the US. However, the New York Convention does not talk about any actions against states. The language in the convention is very clear.
I'm sorry, do you agree that had the arbitration been here in the United States? I want to make sure I understood your answer. Had the arbitration been here in the United States, then sovereign immunity would be waived by virtue of the fact that they arbitrated here in the United States?
Your Honor, under this court's precedent, the court has found foreign sovereigns have waived their sovereign immunity impliedly by agreeing to and ultimately arbitrating in the US, which of course Nigeria did not do in this case.
Okay, but then isn't the whole point of the New York Convention is to make all the signatory countries like one big country? Like if you're in any of them, it's the same as if you're in one of them for these purposes. And so if you're in the New York Convention world and you're arbitrating in the New York Convention world, you are subject to enforcement. You've waived sovereign immunity from enforcement, either of the agreement to arbitrate or the award in this New York Convention world.
Your Honor, the New York Convention contains one core obligation by each of the signatory states, and that's that in their courts, they will enforce arbitral awards that are entered in the countries that are also signatories. So the obligation is not that they're submitting themselves as states to the jurisdiction of the other.
You said they are if they arbitrate in the country itself. I thought you said there is a waiver of sovereign immunity. It's no more explicit, it's implicit. If they arbitrate if the courts and the place of arbitration are the same country.
Your Honor, historically, before the arbitration exception.
Do you agree that that's a proper reading, that was a way? I don't want a history lesson here. I just want a legal answer. Do you agree that had they arbitrated in the United States, they would have been there would have been an implicit waiver of sovereign immunity?
Your Honor, I agree that that would be the case before the FISA was amended to input a specific.
Yeah, we're in a world now where FISA is here. So
but
would they, right today, right now, with this arbitration, had it occurred in the United States, would there have been an implicit waiver of sovereign immunity?
Your Honor, I think under current law with the arbitration exception, which was enacted in the late 1980s, it would not. But historically, this court's precedent was that an arbitration in the United States would be enforceable under the implied waiver. But Congress amended the FISA in the late 1980s to add an arbitration exception, and a counterparty to an arbitration with a state should be pursuing a waiver argument under the arbitration exception, not the implied waiver exception. The core obligation.
The arbitration exception incorporates expressly the implied waiver provision as well at the very end, correct?
As one of the conditions, one of four potential conditions that you have to meet to satisfy the arbitration exception, but you can satisfy the arbitration exception without establishing an implied waiver.
I get that, but if there was an implied waiver before, Congress wasn't taking that away.
Correct. As an extra condition on the arbitration exception. Your Honor, so there's one core obligation for each of the states under the New York Convention, and that is to accept in their courts cases enforcing foreign arbitral awards. Those cases, though, and this is Article 1 of the convention, is very specific. It's for foreign arbitration awards arising out of differences between persons, whether physical or legal. The word states is used in the New York Convention to describe the signatories. What this Article 1, when it talks about the scope of the convention, is dealing with private litigants, whether they be persons or entities. And we know from law that states are not treated as persons. For example, the due process body of law in the United States. The convention made no attempt to submit the states who were signing and agreeing that their courts would enforce foreign arbitral awards that those states were waiving their own sovereign immunity. And of course, there's nothing in the convention itself about sovereign immunity. And I think this court's recent holding in the Ivanenko case is instructive on that point. There was a treaty between the US and the Ukraine. The treaty provided for only for the parties to, which were the states, to entertain civil suits in their own courts. And that's what the New York Convention says, is we will permit enforcement of foreign arbitral awards in our courts. It's not a waiver of sovereign immunity. I think that in terms of the fact that Congress has enacted the arbitration exception is further evidence that the court should not expand the scope of where it's gone in terms of finding an implied waiver, which again requires some level of connection to the United States, whether that be a suit in the United States where the sovereign answers without asserting sovereign immunity, or agrees actually to arbitrate in the United States or submits itself to.
Okay, but I don't know where that gets you, because then you just lose under the arbitration exception.
Your Honor, I don't think we lose under the arbitration exception in this case, because there is no foreign arbitral award to enforce because it was vacated.
Well, we have this court has precedent treating arguments like that it's been set aside or invalid on some other grounds as affirmative defenses. They don't bear on the jurisdiction of the court, which is all we're deciding here and all the district court decided here.
Your Honor, sovereign immunity is different. As this court held on the first appeal.
We've held this in sovereign immunity cases.
Your Honor, on the FISA issue, as the Supreme Court held in the Bolivarian Republic of Venezuela case, which we cite in our brief, sometimes the merits and the FISA jurisdictional issues can be intertwined. However, the court
sometimes they're not. And we have held the Diag-Human case, the Stillix case, we treated the invalidity or asserted invalidity or absence of an enforceable arbitration award as an affirmative defense, not something that bears on jurisdiction.
Your Honor, the exception under 16056 is to confirm an award. And if the award has been vacated, as we contend it has here, then there's no award and there's no prerequisite.
Can I ask you one question, because your time's about to run out here? Yes. I assume when you say it's been set aside, you're referring to the order of the Nigerian High Court, correct?
Yes.
And that says it is setting aside and or remitting for further consideration all or part of the arbitration award. So how do I know they have set aside rather than remitted, and they've set aside all rather than part? How do I know from the face of their order that they've set aside the entire award?
Your Honor, you have to go to the motion that Nigeria filed on February 24th, 2016. That's in the record at page 203. There, they sought to set aside, and in the opening preamble also asked in the alternative.
That's not, no, I should think that we would look at the order of the court itself. And if I can't tell from the order of the court itself, what are we supposed to do?
Your Honor, I think you can tell from the order, because
if I think I can't tell from the order, I'm just answer this question. I understand your argument. I respect that. But if I couldn't tell, hypothetically couldn't tell what it did, what would happen then?
I would ask the court to look at page 24 of the record, which is the motion where it clearly seeks a set aside without again mentioning remitting, which of course means cancel.
Makes things worse, right? That makes things worse for you because they added words that you weren't asking for. So they seem to be doing not what you asked for.
Your Honor, I think it's adopting the form of order that was submitted as proposed, but I don't think.
Did your form order have the word remitting and all or part?
Yes, Your Honor, and it was in the preamble of the motion. However, there was nothing in the order that limits the scope of the vacatur. So I think in reading the motion together with the order, the only conclusion is that the entire award was set aside. Even if the court's unsure about that, which I think the court can become sure on, then it's a decision that the district court would have to reach in order to determine whether or not that order actually set aside the award. And the court, even if it has to delve into the merits to some degree, as the Supreme Court has held, it has to do so, and it can do so in determining the FISA, even if it decides some merit issues along the way.
Does that answer your question, Judge Millett?
Yes, yes,
All
thank
right.
you.
Thank you,
Mr.
Your Honor.
Mr. Clayson.
Yes, good morning, Your Honors, and may it please the court, Joseph Clausen for the petitioner appellee. Judge Millett, you said it right when you said that the New York Convention creates essentially a framework, an international framework for enforcement of foreign arbitration awards arising from commercial disputes. And so Mr. Major said that Nigeria really only committed to enforcing awards in its own courts. But in fact, by joining a multilateral treaty like the convention, every state that does so agrees to have awards enforced in every or any other convention country, including the United States.
Well, they agree to enforce awards according to their own procedures. That's the language of the convention. And our procedures, I should think, would include our principles of sovereign immunity and what it takes to waive sovereign immunity. And in this country, because of separation of powers, from the court's perspective, it takes very clear language to have a waiver of sovereign immunity. Do you know whether the United States government agrees with your reading of the convention? Does the United States agree that its sovereign immunity has been waived if, for example, someone went to Afghanistan and tried to enforce an award against the United States there?
Judge, I do not know the U.S. position, the U.S. government's position. I would say that, of course, a prior panel of this court in Tatneft applied this exact analysis.
Yeah, that was not a published decision. And I mean, it's fair of you to reference it, of course. But I'm concerned because I think your position, the waiver theory here, as opposed to the arbitration theory, the waiver theory here would definitely implicate, as a matter of circuit precedent, that the United States itself implicitly waived its sovereign immunity. And we at least in the past, have generally required a lot more clarity for the United States to subject itself to the jurisdiction of 167 other countries around the world. I'm just worried about this very big step that we're taking. But if the government has already signed off on that reading, then I don't have to worry about that.
I'd say a few things in response to that. First of all, that while the Tatneft case was unpublished, there was a petition for rehearing en banc and also a cert petition, both of which were rejected. So there may have been opportunities for the U.S. government to respond to that. But in any event, to address your specific question, I would say two things. First of all, the waiver, it is true that this theory another court in another country could apply the same rationale that we are asking your honors to apply here. Of course, it's not merely the agreement to sign up to the New York Convention. It is then the subsequent agreement to arbitrate a particular dispute. So it is the combination of those two things. And so if the United States, as a signatory to the New York Convention, then agreed to arbitrate a commercial dispute, then by the same rationale, indeed, if another court applied the same rationale, then they would have waived immunity. That does not mean, of course, that the award would actually be enforced. And that really goes to the heart of the issue here, which is that the jurisdictional question as to whether the court has jurisdiction to decide whether an award should or should not be enforced, that is separate from the question whether the award should or should not be enforced. And so in your hypothetical, Judge Millett, that the United States would presumably have various arguments under, Article 5 of the New York Convention as to why a particular award should not be enforced.
But your position is that's not a jurisdictional inquiry. The existence of a legitimate award is not a jurisdictional inquiry.
That's correct.
So someone could go into a court in the Russian Federation and they pull out on a piece of paper written in crayon, and it has some little stamp on it. And they say, here's our certified arbitration award against the United States government. Enforce it, please. And the United States would have to subject itself to jurisdiction and litigation in that court over and then litigate, maybe have discovery before it could hopefully extricate itself, or maybe not, from that judgment. But I just, if the United States government, if the political branches have agreed to do that, then it's not for me to question. I'm just concerned about this notion that you don't look beyond sort of the face of this piece of paper that purports to be an award until you've exercised jurisdiction, and then they can be drawn through discovery and all kinds of other proceedings before there's actual decision on the merits.
Right. Well, first of all, Judge, I would say, I do not know one way or another what the U.S. government's position is. They could also have appeared or sought to intervene in this case, and they haven't. And I just don't know what their position would be on the waiver. But yes, you're correct that under this theory, they would, the United States, if they agreed to arbitrate the dispute, would be subject to the jurisdiction of courts of other convention countries. Of course, under your hypothetical, if a Russian court were then to say, based on, what the U.S. would consider an invalid award, and the Russian courts decided to enforce it, there's still the question whether the United States would actually end up paying the award, first of all, because they might choose not to. And if there were assets in Russia belonging to the United States, I don't know that there are, but if there are, there would be immunity from execution as well as to particular assets. So it by no means means that it's that decision to waive immunity, the implied waiver, would result in, for example, the seizure of U.S. government assets.
If the just do a hypothetical, because I know there's litigation about this issue, but if you have an arbitration award, and then 2 weeks later, it's set aside by, shall we say, like the same arbitrators, or it's an arbitration appellate panel of some sort, but in the same jurisdiction, everyone's a signatory to the convention. And so it's set aside in sort of like a New York minute, right? This award doesn't last very long at all. Is it your position that the person who had that original award, which is on it clearly as a matter of public record, been thrown out completely, could still go and take that award into a court here in the United States and say, please enforce it? And when that foreign country comes in and says, what are you doing? France comes in and says, what are you doing? That thing was set aside. The district court would have to go, I can't look at that. They came in, they showed me an arbitration agreement, a treaty, and an award that's got a stamp on it. And you're going to have to go through, subject yourself to our jurisdiction and go through litigation before I can address the existence of a valid arbitration award.
Well, Your Honor,
it's not a jurisdictional fact.
Right, it's not jurisdictional, but I would take issue with your characterization of the award having been thrown out, because the New York Convention expressly contemplates that an arbitration award, and in that sense, it's different from a court judgment, that an arbitration award, which is a private dispute resolution mechanism, right, that an arbitration award can be enforced. And in fact, the New York Convention essentially requires awards to be enforced, but that it can be enforced even if it has been set aside. And if there has been a lawful set aside in the sense that there was a court with supervisory powers under Article 5 of the Convention, then that is something the court can consider as part of the merits analysis as to whether the award should be enforced. So it is different. It's not thrown out. There is a court decision that certainly casts doubt on whether the award should be enforced, but it does not affect the jurisdictional analysis. And Judge Millett, you mentioned earlier the Diag-Human case. That was actually, that was a situation I think when you started your hypothetical, you mentioned that the award had been, reversed by another arbitral, panel. I think that's what you said. And that was the exact situation in Diag-Human, where there had been an arbitration award, and this court affirmed the decision to confirm the award. And it then noted at the end of its judgment that during oral argument, a question had been raised as to whether the award was still final, because there actually was another arbitral appellate panel, which is pretty rare, but does happen, an arbitral appellate panel that had arguably vacated the award. And this court said in that decision that went to the merits of whether the award should be enforced and confirmed, not to the jurisdictional question. And as for situations where a court might have set aside an award, this court recognized in Termo Rio that, albeit in exceptional circumstances, an arbitral award can still be confirmed even if it has been set aside at the courts of the seat or any other court that might be considered to have the supervisory jurisdiction under the terms of the New York Convention. So I see my time is up. Unless there's other questions, I will rest on the briefs.
All right, Mr. Clayson. Mr. Major, why don't you take 2 minutes?
Thank you, Your Honors. While the New York Convention may contemplate an enforcement proceeding, even if there's been a set aside, we're talking about the Foreign Sovereign Immunities Act. And the court in the first appeal in this case held that the immunity is from suit. It's not immunity from liability. So Nigeria is entitled to have an upfront ruling on its sovereign immunity. One of the threshold questions, to the extent the arbitration exception to the FISA is going to be argued by PNID, is whether or not there's an arbitration award to enforce. That's a requirement of the FISA, regardless of whether that requirement exists in the New York Convention, which again deals with private party litigants, not states, like the FISA does. So that has to be decided as—
Where does the FISA require that the existence of a valid arbitration award be determined as a jurisdictional fact? Where does it say that in FISA?
In 16056, it says the arbitration exception is to enforce an agreement, or, as applicable in this case, to confirm an award made pursuant to such an arbitration, an agreement to arbitrate. If the award has been set aside, it does not exist, just like a judgment under—
It doesn't say that in FISA. It just says there has to be an award, which is the same thing our precedent has recognized. They come in with you have to have, I think, a certified copy of the award, or once you have that, then any other questions about its legitimacy can be addressed on a motion to dismiss. The jurisdiction exists. You need an agreement, a treaty, both of which you don't dispute you have here. And I think the adjective is certified award, which there is here.
But Your Honor, an award, just like a judgment, if once it's been set aside, it doesn't exist. Just because the piece of paper still exists doesn't mean the award itself exists. And there has to be an award under the FISA for that arbitration.
Well, the convention itself says you may not, a court may decline to enforce. It doesn't say it has to if it's been set aside. So I don't think it reads it that same way.
The convention,
and FISA doesn't address that situation. There's nothing in the statute that addresses that.
The convention is not a sovereign immunity treaty. It's an agreement to enforce in your courts arbitration awards overseas between private litigants, persons, whether human or under law, which is distinct from states, both under the language of the convention and under historical law. Your Honor, so here, without the award, there is no arbitration award to trigger that exception. And that's a threshold question that has to be decided, even if it requires delving into the merits.
All right. Thank you, counsel. Madam Clerk, if you'll give us an adjournment.
Thank you, Your Honors.
This honorable court is now adjourned until Friday, November 12th at 9:30 a.m.